And before your lordship takes up the record, my lord, may I just cut short the matter?
In this matter,
the thing is this, my lord, in 2021, the petitioner before your lordship had approached the learned tribunal, Central Administrative Tribunal, challenging a parallel proceeding, departmental as well as criminal proceeding.
I appeared for the petitioner.
He sought for a
This is
stay
the
order
affidavit of
in
service.
respect of the departmental proceeding.
Affidavit
Because
the affidavit
self-same
is
set of
respondent.
facts and charges
Before
were
your
there
lordship
in
takes
both
up the
the
record,
matters.
may I just
Now, Lord,
cut short
Paul
the matter?
Anthony and other cases were relied upon. Initially, Lord,
The
for
thing
a
is
limited
this, Lord,
period, an interim
in
order was granted in favor of
2021,
the
the
petitioner.
petitioner before your
Now,
lordship
Lord, the
had approached the learned tribunal,
considered it
Central
fit
Administrative Tribunal,
to remit the
Lord,
matter to the
challenging a
concerned
parallel
authority
proceeding,
for a decision
departmental as
after,
well as criminal proceeding.
after due
He
deliberation
sought
of
for
the
a stay
judgments,
order in respect
Lord,
of
in
the
the
departmental
field
proceeding.
regarding, Lord, parallel
Because
proceeding, whether
self-same set of
departmental
facts
proceeding
and
can
charges
continue
were
or
there
not
in both the
during the
matters.
pendency of the
Now,
departmental
Lord, Paul
proceedings.
Anthony and
So,
other cases
the
were relied
petitioner was
upon.
directed
Initially,
to submit a
for a limited
representation,
period, an
detailed
interim order was
representation with
granted
all
in
the
favor of the
judgments.
petitioner.
That was
Now,
done
Lord,
till such
the
time the
tribunal
stay was
considered
continuing.
it fit
Now, Lord,
to
the
remit the matter to
petition
the concerned authority for a decision
after due deliberation of the judgments, Lord, in the field regarding, Lord, parallel
all the
proceeding,
judgments
whether
were
departmental
submitted,
proceeding can continue or not during the pendency of the departmental proceedings. So the petitioner was directed to submit a representation, detailed representation with all the judgments. That was done till such time the stay was continuing. Now, Lord, the petitioner submitted the representation along with all the judgments, including which are in favor of the petitioner as well as which are against the petitioner. All the judgments were submitted along with the representation.
Now, Lord, the concerned authority, Lord, took a decision, Lord, that this is, Lord, a complicated question of law. So we should depend upon the decision of the learned tribunal. We are not just interfering with anything whether parallel proceeding should continue or not. So that was the decision. Now, Lord, the tribunal was in session of the matter. Hearing was on. Lord, in the meantime, Lord, we filed, the petitioner filed one application for, Lord, an application for modification. Yes, the one miscellaneous application was filed by the petitioner for appropriate order regarding the affidavit which was filed by respondent number 1, opposition. Lord, the tribunal also wanted to know whether he is at all competent, because there was, Lord, whether he was authorized. The reply.
What is the scope of interim order today?
Lord, interim order, Lord, I would humbly submit before your lordship, Lord.
The original application has been dismissed.
Yes, Lord, the tribunal proceeded on a, Lord, erroneous basis. I never challenged the charge sheet. I never, if your lordship sees the last paragraph of the impugned judgment, I never challenged the charge sheet. What I challenged, that is not the parallel proceeding, whether departmental proceeding should continue during pendency of the criminal proceeding. That was my challenge. Accordingly, Lord, the tribunal, Lord, was
Paragraph 7.
paragraph 7. Paragraph 7 of the tribunal's order, Lord. After perusal of the entire record, the sole question needs to be adjudicated is that pending a criminal trial, whether the disciplinary proceeding can be stayed, and in consequence thereof, whether the charge sheet can also be quashed by this tribunal.
Very possible. Because in the prayer portion, you must have given stay stroke quash.
No, Lord. That is, and if your lordship, Lord, considering, your lordship, kindly see the last but one paragraph of the impugned judgment, paragraph 9.
Yes.
Considering the
considering the above preliminary objection with regard to non-admissibility of this OA under section 19 of the Administrative Tribunals Act 1985, as a charge sheet is not considered as an order against which the applicant is aggrieved, and in the light of the aforementioned judicial pronouncements on the subject, we are of the opinion that this OA against the charge sheet is not maintainable. I never challenged the charge sheet. Page 46, if your lordship kindly come. Prayer made in the original application. Prayer made in the original application. paragraph 8, A. I never challenged. The tribunal proceeded on an erroneous basis altogether. And ordered to issue, thereby staying the entire departmental proceeding so initiated against your applicant, while memorandum number so and so, till the disposal of the criminal proceeding so initiated against your applicant, as the charges are same and identical, both in departmental proceeding as well as in criminal proceedings. And order to issue directing the respondent authorities to reconsider the representation dated so and so made before them after giving an opportunity of hearing to the applicant herein, and to dispose of the same by passing a speaking and reasoned order within a stipulated time period. And order to issue directing the concerned respondent authorities to transmit all the records before this honorable tribunal in aims of justice. Any other appropriate order, I never challenged the merit of the charge sheet. The tribunal proceeded wholly on an erroneous basis, my lord. I only sought for a stay of the departmental proceeding because my defense would be prejudiced. If the department...
That stay was paid for in the earlier application also. Matter was relegated to the competent authority.
No. In the matter was kept pending.
That was kept
pending. The interim order was allowed to continue till the decision is taken by the concerned authority on my
Where
representation.
is that order?
Page 7. প্রথম order.
চার্জশিটের ফার্স্ট পাতাটা দেয় না অনেকগুলো
Page 193.
এটা তো
আপনারা যেটাতে বললো যে এটা রিপ্রেজেন্টেশন দাও পেন্ডিং থাকবে।
Now, Ms. Alam, the disciplinary proceeding is at what stage? Inquiry officer appointed?
No reply has been filed even, Lord. Statement of defense has not been filed. I challenge the, when the charge sheet was issued to me,
Let the proceeding
let them start and we can let him participate in the proceeding.
Lord, kindly see, Lord, page 213. Page 213.
We will protect you to the limited extent subject.
We shall file the,
But we cannot stay. The proceeding will continue.
Lord, my defense would be prejudiced. Lord, Paul Anthony would support me subject to your lordship's kind consideration, Lord.
Lordship, Lordship, in
Lord,
my
I
Lordship.
annex all the judgments.
the two
Which are-
issues are entirely different.
You have
Lordship,
successfully kept the disciplinary proceeding pending for more than 3 years.
Lord, let the criminal proceeding be over. Then let them start.
Lordship,
What he has
whose in hands is the criminal proceeding?
The charge sheet has already been filed in the criminal
Only in the year
as I am told, sir.
2022.
Hmm?
Then what is the fate? Nobody knows. And Lordship, how long? Lordship, are a case of 4.22 crores misappropriation. Lordship is a
I-
very serious case.
Lord,
What
that
started
would
off
be-
with
Lord,
3.02 crores in the
I-
FIR,
I would be-
ultimately,
not-
Lordship,
not-
but audit
not
was
only upon
held,
me,
it
Lord.
went up to
Other
4.22.
accused are there. Let me fix
And
the
then
criminal
that
proceeding.
we have to bear with a person like that. I mean, without any kind of punishment. Lordship, this has been going on. And we started the disciplinary proceeding, the charge sheet was being delayed. That charge sheet was filed after the
Has your
disciplinary
inquiry
proceedings.
officer been appointed?
Lordship, I have to seek instructions. I just got the brief yesterday, Lordship.
Come with instruction.
I'll come with Lordship will kindly keep it
After vacation.
after vacation. I'll come with instructions, Lordship, and then Lordship can get it.
Lord,
The inquiry officer has been appointed. His only ground is disclosure of defense.
yes, Lord.
That is his only
Otherwise,
ground.
we were minded to give him a protection that no final order shall be passed against. But
Lordship,
if your
but
ADO was
Lordship,
very-
Lordship will kindly see there is a difference between the two. Here it's a violation of the conduct
Lord,
rules.
Lord, I go by your lordship's observation, Lord. I go by your lordship's
Lordship
observation.
will kindly keep it
Let
up.
the proceeding continue. Let the proceeding continue. I would definitely take part in the proceeding, but no final order would be passed without leave of the honorable court, Lord. Without leave of the honorable court.
Then your entire purpose is frustrated, Mr. Rai.
If he's
No,
willing, let, because Lordship, there are two different aspects
no.
altogether. One is the offense.
That's correct, Lord.
Think twice, because once you participate, your defense get dislodged. you will not be get an interim protection on this ground. Think
No,
over it.
no,
And if you say that, yes, I am desirous of continuance of the proceeding, we will dispose it of.
We do the
record.
right now.
We dispose it of.
Lord, then we're second option. That's correct, Lord. My argument would be frustrated. That's correct, Lord. My argument would be frustrated.
Lordship, let me come back to the instructions.
No. Second option.
Maybe not,
I go by
Lordship,
second option.
because the
Let
subject
my
of the
learned friend take instruction.
Lordship, I shall
I
seek
should also take instruction from my client.
Heard the Lordship, heard Mr. Royal Learned Advocate appearing for the petitioner. This alarm is learned advocate appearing for the respondents is directed to avail necessary instruction. Still discuss matter for further consideration under the same order 2 weeks after the
Lord, meanwhile, Lord, some protection.
Lordship.
No.
No.
4 years matter you have success.
Lord, till such time, Lord, till further consideration. No, till further consideration.
How success?
Lordship, this doesn't merit.
No, Lord, till further consideration, Lord,
Enough. Yes.
I'm getting
Lordship, 1 week after vacation.
2 weeks.
2 weeks.
2 weeks. 2 weeks. Yes.
I'm grateful to my.
Item.
Mr. Orko Chakraborty is appearing on behalf of the petitioner.
2 weeks. Next 2
Great.
weeks after vacation. ওটা এফিডেভিট ও সার্ভিসটা দিয়েছিল আগের ম্যাটারটা yes next yes item number 12
Yes, Your Lordship. For the petitioner, Your Lordship. Your Lordship, the service has not been completed yet.
learned advocate.
Your Lordship, one indulgence, one prayer, Your Lordship. So, I'll give a backdrop of facts, Your Lordship. I'll give a backdrop of facts. It's a prayer, one prayer, Your Lordship. Yes,
come sir permission
Your Lordship, there's a review application pending, Your Lordship. Your Lordship, one indulgence is that if the review application and this can be heard out together, Your Lordship.
please heard first the learned advocate.
Grateful, Your Lordship.
That service upon the respondents is not in view thereof is the matter for further consideration under the same heading after the vacation. The petitioner is directed to the petitioners are directed to complete service upon the respondents in the meantime and file an affidavit of service. Yes, next 13.
I appear.
Anything, any interim order?
No, urgency is this petitioner is not getting the pensionary benefits for less than 6 months. First round of litigation, they have admitted before the tribunal that it will be condoned. On that conspectus, it was sent before the authority for consideration. The authority rejected. Since it is within as per section 13, rules 36, it may not be condoned. The discretionary power, it may not be condoned. Again, before this tribunal. Tribunal, upon consideration,
Your deficiency.
5 months, 9 days. But kindly see, it is
Months 27 days.
27 days. That means at page,
Just near to the border.
yes, because of the fact,
Some say T20 match.
no, it is a fault. It is the fault on the part of the authority to give me appointment within time as per direction of the honorable division bench. 5 months or 6 months.
You have not said all these things to the tribunal.
Yes, all these averment.
Vociferous before us.
But all this averment with all annexures. So, my lord,
Let us see.
my lord.
It appears the tribunal's proposal was not.
The government is yet to take decision in terms of the order of the term.
a fresh proposal for condonation. Why fresh proposal?
Under the statute, authority cannot go beyond the statute.
To reconsider the proposal.
That is agreed. 4 years.
The earlier High Court order.
Yes, my lord, earlier time of page 64.
Then what did the High Court say?
No, initially High Court said regarding my appointment.
Said that High Court has said that you grant him the benefit.
No, not that. At the time of initial appointment, I am saying. At the time of initial appointment,
Want to contest on that, let them come with affidavit, we will finally decide. You are not inclined to go for reconsideration.
No, because of the fact, if reconsideration is part of considering the honorable division bench is there one part. Now regarding my lord area, all these things is there. That is why my lord it is agreed.
When did you retire?
2020,
2020.
4 years.
4 years. So 2020, when did you make representation for condonation?
Immediately thereafter, December 2020. Thereafter, first round,
Your appointment was the post of what?
my constable exercise.
Constable exercise. So it is you are not an organizer teacher. That you had worked for some time thereafter the court
No.
order.
So therefore,
Then Mr.
36, no, it is there. The government has a power of discussion. And I have quoted, I have annexed all these rules.
We have delivered, we have done the next stage also. We have delivered a judgment. That is why he is so quiet. He's quiet.
So, my lord, subject to correction, my lord.
Your opposition, Mr. Mukherjee, will decide. And are the learned advocates appearing for the respective parties? Upon hearing the learned advocates appearing for the respective considering the materials, we are of the opinion that in which matter reconsideration will not help you.
That is there. But division bench already, my lord,
We are of
quoted.
the opinion that the matter needs to be decided upon exchange of evidence. The respondents are accordingly directed to file their affidavit in opposition within 2 weeks after the vacation. Reply thereto if any filed thereafter. Stop. The parties miss the matter for further consideration under the same heading. Under the same heading, table supplementary is the discord 4 weeks after the vacation.
My lord, affidavit of service, because of the fact, my lord,
Telling the order taking substances passed by the tribunal. Yes, next.
in the meantime, they have issued one notice for consideration. In the meantime, after filing, they have issued one notice.
So, Mr. Please make up your mind.
No, no, let it be, let it be. No, I want from your lordships, order from your lordships.
Next.
Much obliged. Grateful to you.
Yes, 14.
Not arm for the petition.
Lordship, I am appealing for the state respondents.
The urgency resort
Well, urgency is one of the
1
selection.
week after vacation. Yes, next 15.
My lord, 15 and 16, my lord.
1 week.
Mr. No, my lord. I am only paying not today, my lord. Mr. My lord, Mr. Vikas Ranjan, what is happening? He is not
Not this week.
able to. Only to, not today, my lord. Right there, my lord.
Come back on the reopening. Not this week. Yes, 18.
15 and 16, my lord. Both.
Not
17.
17.
weeks after.
Item number 17, your lordship, I appear on 17. 17, I appear on behalf of the state, your lordship.
But in this matter, Mr. Siddhartha Banerjee is leading me.
18.
Item number 17, my lord.
17, we have kept it in the reopening. 17, title. Not this week. Yes, 18. Who is it?
I appear on behalf of the state, your lordship.
You're for the state.
Yes, your lordship.
1 week after the vacation. Yes, next. 19. 19. 19, who is there? 1 week after vacation.
My lord, I am for the petitioner. I humbly prefer short pass over pen. Ranjan,
What password? Not this week. Yes.
19 years.
20, 20. 20,
Yes, 6, 21.
21. 20 also 1 week after vacation. Not this week.
21.
I appear for the petition.
The brief bhule gেছে এত brief হয়ে গেল এই 21 you are there.
No, 22.
They are called 22. 21. 2 weeks after vacation. Yes. Check.
Orders are for
But here, the petitioner participated in the selection process, my lord, for the post of fire operator, my lord. But conducted by the Public Service Commission, my lord. My petitioner participated in all the proceedings, my lord. Thereafter, the name of the petitioner was recommended by the Public Service Commission, my lord. At the police verification, my lord, since no appointment was being given, my lord, we filed a writ application, original application before the Planet Tribunal, my lord, and before during the hearing, my lord,
বাংলাদেশি ন্যাশনাল
হ্যাঁ বাংলাদেশি বলছে কি বলবো বলুন তো
সাহস হয় কি করে বলো তোদের মামলা করতে সাহস হয় কি করে এখনই তো জেলে ভরবো
সব জমি জমা পাবি তো কি
জমি জমা
ভোটার
ফিরি
লিস্টে
হলো পাঁচ নয় 2023টা কোথায় দেখা
page 55
পরেরটা দেখি
একটু তো অর্ডার থাকে
আমার 55টা দিস নাই
নেই
54 এর পরে নেই
হ্যাঁ না এই 54 না এই 54 But I filed an original application before the London Tribunal, my lord, which has been disposed of by considering a purported report of the Home Department that the petitioner's parents are Bangladeshi nationals. But I have the documents, my lord, which reveals that I am all along, we are the citizens of India, my lord, we have the documents, my lord. In the voter list, my lord, our name are appearing, my lord, and from the, we have purchased the property, all the documents.
When was the selection over?
But the selection proceedings was initiated in the year 2018, my lord, the last.
The police verification report is against you.
But no opportunity was given to the petitioner to contradict such report, my lord. On the basis of that report, my lord, by relying upon page 55, my lord, but the order has been passed, or impugned order has been passed by the London Tribunal.
55.
Page 55 is the report of the, my lord, the department, Home and Hill Affairs Department.
It is purely confidential although it was disclosed before the court
But-
police verification report
Yes, sir, the applicant could not
And not-
give any document in support of his Indian nationality
My lord.
during the inquiry.
But no details has been given, my lord. My last paragraph, my lord.
Opportunity is you are giving to him to body document.
But no opportunity was given, my lord.
Since the applicant has
But-
not been able to file 11 documents in support of his claim as an Indian national, the pair of the may pair in this application for direction issue appointment letter has become intact.
But no opportunity was given, my lord, to contradict. But the report, which was which was handed over by the Home and Hill Affairs Department, my lord. Page 55.
Verification of Antecedents in respect of Sudhir বিশ্বাস.
Well.
Reference in the understanding identity study, date of birth, last have been measured found correct. Discrepancy arises regarding nationality of the inquiry. Here did not produce necessary documents in support of his nationality.
But all the documents are there, in the writ application. I have annexed voter card, Aadhaar card, as well as all the.
Aadhaar card is a conclusive proof.
And in the voter list, my names are appearing, the caste certificate also issued, after inquiry,
All are fake. He is not an Indian national.
Yes.
Bangladeshi national. Where is the passport?
Passport করতেই হবে citizen হতে গেলে
You are not the commissioner. You are our officer. ও এখানেই কোর্টে ঢুকবে।
আরে পাসপোর্ট করতেই হবে citizen হতে গেলে।
Have you
Parents are still Bangladeshi.
No, in the voter list, I have my names of the parents are appearing, not only new, since 1995, I have annexed, the property was purchased by the grandfather, by the grandfather, purchased the property.
of CA judgment which was there? Then your passport may not be treated as a proof of your citizenship.
But the document reveals, all the caste certificate, educational qualification, birth certificate.
For us, what can be done?
But I have annexed,
We have to hear that appointment. When was your appointment letter? When was your appointment letter issued?
No appointment letter, I select in 2023, the list of successful candidates was published, by the PSC, where, my name is appearing, Page 40. তো কাউকে না কাউকে বলে দেবে
ওই অর্ডারটা করে দিও।
You have what document have you got towards your citizenship?
the voter card, Aadhaar card, and as well as
Passport.
no, I do not have the passport, but the caste certificate after inquiry, the caste certificate was issued by the SDO.
How can that prove your citizenship? Caste certificate, how can you?
But the
How need some
sale deed is there, I have purchased.
any authority?
But in the voter list, my names are appearing.
Now the law has.
Well,
You come prepared and tell us, then we will consider.
but no opportunity we given, to contradict the report.
A disputed question. Huh? You are saying no opportunity. He says that yes, it was given. Tribunal records, yes, it was
No,
given.
tribunal by relying upon the input, the
Right, because in that document at page 55, it has been stated that you did not produce documents. See, second clause of page 55.
During inquiry.
Discrepancy arises regarding nationality of the subject. During inquiry, subject did not produce any nationality. So let them enclose in the inquiry proceeding.
and the no details has been provided. I kindly see, that during the inquiry, it has been established that both his parents are residing and working in Bangladesh. No details has been provided. Only the
Imperial Government of India is a party.
এটা তো আপনার government,
No, no.
Yes, sir. The
Government of
present
India.
petition has been preferred challenging an order dated such and such passed by the learned tribe. Such and such upon hearing the learned tribe. Please agree. So what are evidence direction? To be decided upon.
CPM technical.
Opposition within 2 weeks,
Or can you make it 3 weeks?
3 weeks after vacation, reply there.
1 week.
File within a week there.
আমি যে বাংলাদেশে বলে দেবো
বাংলাদেশ
ওই
না বাংলাদেশ
কি বলে দেবো আরে বিএসএফ কে বলবো
সব ডকুমেন্ট আছে
তো সোশ্যাল মিডিয়া
15 July. But meantime, some protection, but one post,
If you succeed, post will be there.
or steps taken, steps taken in the meantime, steps taken, shall abide by the result.
An absurd detection. Acha, wait. Constable,
No, the fire operator.
Mr. Mukherjee, take instruction and come.
What are the, so far as Bangladeshi national is concerned, because there is a public relations directing the certificate issued by the competent
I
authority,
want to know from you exactly. We will hear it. Suppose
or because the matter is
we
now
will
pending before,
dispose of the matter, you produce.
no, because the matter is pending before the Supreme Court
Which matter?
regarding the caste certificate issued by the different officers of the Bangladeshi nationals.
But I have annexed.
Challenge in a public interest litigation. Then what are some of the candidates to the Supreme Court? Then Supreme Court not only put a directed
Appeal in the public interest review and caste certificate was cancelled.
cancel, and some of the doctors who have got admissions, they have been removed from the medical colleges. And
But I have annexed the birth certificate issued by the government of West Bengal.
your part will not prove.
আরে সেটা ঠিক আছে।
Where did you do your primary study?
But in all, I have annexed all the testimonials in the, with the all the West Bengal, my lord. West Bengal Board of Secondary Education, my lord.
Primary.
Oh, primary. My lord, I have annexed, my lord, the
Show us any document, judgment, any authority that once I have a caste certificate, you have to apply.
no, my lord, I have annexed all the testimonials, my lord.
Show us it, because the law is constantly shifting on the issues. You show us any authoritative judgment on the point.
My lord, I have annexed.
That I am entitled to an interim orders because this point has not been finalized. We will give you the relief.
But I have annexed, my lord, the mark sheets.
আবার বলে
No, no, no.
আরে পারলে তো পাবি তো।
That's
But Mr. Sachin sir, Mr. Mukherjee granted for the state response is directed to avail necessary instruction is given power of certificate. In the date, same heading. 2 weeks after. 2 weeks, not 3 weeks, 3 weeks after. Bring the judgment.
My lord.
My lord, item number 20 was taken up, but my learned friend was not present, my lord. That one, it's a very urgent matter, my lord. My application, my lord, that was your lord.
How will be opening?
My lord, my learned, my lord, but there is some urgency, my lord. Kindly take it up because, my lord, why I am, my lord, insisting, my lord. My lord, my review application was dismissed on the ground, but I am not getting.
Where neither your junior was.
No, my junior was there, my lord. He was there, my lord. When,
Listen to it now. What is the why? What is
my
the
lord, but my lord, the only difficulty is this, my lord, I am not getting any benefit, my lord. Retirement
21 to the
20, my lord, 21.
no, no. We have action. Those matters we have please do. You are 21.
No, 20, my lord. 20,
20.
20, my lord.
You are in 20.
Yes.
Why did you say 21?
No, no, my lord, I said 20, my lord. 20. My lord, I said 20.
21 বলেছে অন্যরা সবাই everybody listen 21 না
My lord, then I may be.
Action.
I am sorry, my lord. I am extremely sorry, my lord. 20, maybe, my lord. Sorry, my lord. I am mistaken. But review application was dismissed.
Reject today what?
Oh, my lord. My lord, review application was rejected on the ground of limitation, my lord.
দেখি দাও
But kindly see the order into. My lord, the petitioner,
so what is your urgency? What is
or the urgency is this, my lord.
interim order you want tell us?
But the interim order, my lord, if your lordship sees the order, my lord, today.
What interim order you want?
But the interim order, my lord, there is no scope for
There
my
is
lord
no
filing
scope,
any
your
affidavit.
lordship.
Because, my lord, your lordship kindly,
It is
kindly,
done on the reopen.
my lord,
Yes,
my lord,
yes.
kindly see the order passed by the tribunal, my lord.
On the ground of limitation. So
Okay.
limitation is on the ground
Yes.
of limitation.
Yes.
Only on the ground of limitation, my lord.
Then we will, there is no scope for interim
No,
order.
no, your
That
lordship.
we are keeping it in the list so that we can dispose it. Come after vacation. Yes, next.
Grateful, your lordship.
That order.
Before that, এটাও করলে আর্জেন্ট বলে ইন্টারি অর্ডার
The 2 weeks one is karo. But if they want to use any affidavit, let them, my lord. Otherwise, if they want to use any affidavit, my lord, let them. Otherwise, on that day, my lord, again, my lord.
Such mastering, such and such. Learned advocates and consider the year of the opinion that the matter needs to be according to respondents and it's like they are to be thereafter is the matter under the same heading, in supplementary 3 weeks after.
3 weeks.
Grateful.
Yes, next.
Grateful, Your Lordship.
Before the next matter is taken.
Executive service file.
Whereas before the next matter is taken up, mine was item number 17, which was today specifically fixed for considering the interim protection grant to be granted to me. The state government asked for an adjournment. They were to answer today. My lords were initially of the view that the matter may be taken.
Where you appeared.
My learned junior was there. Mr. Rakib Khan, my learned junior was there. May I serve a notice come back on Friday? I desperately need an interim protection. He didn't say anything. He didn't say anything. Couldn't understand it. I can understand. I have.
How long in this court?
2 years only.
When I first entered the profession, you have heard the name of
Sotero.
Justice Bosar, then Bosar, Bimal Bosar.
No, he has not.
First day of the profession, I entered with him. My senior was not. So I said, my lord, kindly answer. So my lord asked me that when did you join the chamber? I said, I have joined it 1 week earlier. I have started coming to court for 3 or 4 months. But remember what? In this profession, there is no learner's license. You have to start from the first. And we started reading from the cost item. My lords gave it. Here. Who is your other side?
Miss Oshmita Milad is Oshmita's surname.
Your other side, who was your
Miss Oshmita Ghosh Milad was appearing. Chakraborty. Miss Oshmita Chakraborty Milad was appearing. She was there. She was there. Milad, I've seen her. She's on her way, Milad. I'm told she's on her. I'm so grateful to you, Lord.
No, kindly before the fixed.
No mentioning.
No, that medical matter, Mr. Mukherjee is here. Item number.
Can be done, sir. We are trying our best here.
I'm not blaming. I'm just requesting, if it can be,
We are also requesting. Come after vacation.
Not after vacation.
What is your problem, sir? You want to get the admission in a government college. This year you will not be getting. You will be getting, if at all, from the next year. So what is the urgency, sir? Tell me.
I leave it to you. What your lordship is perhaps not passing through your lordship's mind. That
how do you know what is passing through?
Something is passing through your lordship. That is not the issue here. There are certain other issues. Mr. Mukherjee requested he will not be available on Friday.
Why?
Relative expired and one of my relative expired last Tuesday and something.
What can be done? Did you get a vacancy, Mr. Mukherjee? Did you get any vacancy?
According to the order of the Supreme Court, 3 vacancies were.
No, that you told us. You are wanting apart from those.
Apart from this, we are searching because the person who was dealing with this matter, he has been hospitalized. And the 3 vacancies are available in medical colleges.
Mr. Mukherjee come after vacation, let him come on that date. Yes, the fixed matter to doctor.
After vacation? After vacation?
What happened?
38 after vacation.
30.
Medical matter.
Medical.
It will remain in the list. Otherwise, again, it will go down. Again, you have to mention. Let it remain in the list.
Friday it will appear.
Friday, if Mr. Mukherjee is not there, remind us. Or we keep it not, Mr. Mukherjee. We keep it not. If he is not there.
Any event, he says that he's going to come with instructions.
If it is reached, please remind us that.
But I am for the National Medical Commission.
You then remind us. You can see also. Mr. Mukherjee then.
Mukherjee will find out the vacancy. Or Mr.
Not.
But 23, 24, not possible because class started in November. If he is to be admitted in 24, 25. But
we know that what we are asking you about the vacancy status. What will be the session? What will be whatever we will
At
pass
present,
our
what 3 vacancies are there in at least at present, what 3 vacancies available in medical colleges.
That is subject to final result of the Supreme Court, my lord.
We have asked you, Mr. Mukherjee, apart from those, whether there is any vacancy,
That information
that will get instruction, come with a written instruction to us so that we can proceed to dispose of the matter. Let him not suffer indefinitely. Let him know the fate of the litigation. Yes, next. যেটা fixed আছে বল। Yes.
My lord, I am appearing for the writ petitioner.
Fixed আছে, হ্যাঁ।
My lord, although hearing was concluded on 8th of February, but on the last day, I apologize, my lord. I was not here, my lord.
Otherwise, we would have taken it up on that day.
My lord, a point was raised that he is not getting the DCRG benefits, the pensionary benefits to some extent.
No, Mr. Gupta, tell us one thing.
But other matter release.
No release system. You have to wait. You have to wait. Mr. Gupta, the
My lord.
person retired on 30th September 2007.
17.
Now, he preferred the first original application of 189 of 2013.
13.
He challenged your recovery memo.
My lord.
12th of September.
My lord.
Sorry, 19th of October.
19th of October.
That was disposed of on 16th of February 2018,
18.
saying that you could not have made the recovery.
Yes.
Disbursed the amount.
Yes.
Now, that was one part of it. Next, a charge sheet was issued to him on 29th of June 2017.
My lord.
After the charge sheet was issued, that was again challenged. That was OA 1366 of 2001. And he preferred another OA of 133 of 2020 for release the DCRB benefit.
Yes.
Both the applications were taken up and disposed of on 20th of May 2022, saying that the charge sheet itself is bad. If I am not wrong.
No, charge sheet was dropped.
Oh, yes, the charge sheet by that time was dropped.
By presidential order.
Now, our query, because you showed us a circular of the visit, since your argument was that you cannot mix up this with a regular recovery proceeding, because under our department we have a manual which permits us to recover the amount after issuance of a show cause. That was your argument.
Even after retirement.
So we will, so far as the charge sheet, if it has not been, charge sheet was not
culminated into a proceeding.
The charge sheet was issued when he was in service.
Yes.
Now, then this charge sheet has been dropped. There is one clause under subject to what he says. CCS pension rules, one clause is there, that even after retirement, a fresh proceeding can be initiated if there is capital loss to the government.
Well, my query, my answer is that the issue involves here is recovery. Recovery means realization of the amount.
How will you recover, Mr.
The law is there. I shall place.
That law is not applicable to him.
Well, kindly come.
The relationship has ceased.
Even after that, we can recover. That is the rule. Kindly come to the supplementary affidavit that lately filed. We have lately filed it on 2022.
When was this charge sheet withdrawn?
Order dated 20th April 2022.
Annex that.
My lord, I have given us a compilation. I have given a compilation. Page 14 of that. Page 14 of this compilation.
Page 14
of the compilation which I have given. I can give another.
Page 14.
Yes.
Second, 20th of April 2020. Then this was produced before the tribunal and your application was disposed of.
No,
At that point of time, that was not there. It was disposed of, directing the respondents to conclude the proceeding. Everything is there. Whatever you want to do, you conclude it.
Oh, I see.
Conclude
That was the order dated. Where is that order?
order.
Page 11 compilation.
Page 11.
So this was on 20th May 2022.
Yes, that was communicated to me later.
Then when was this withdrawn? Where is that letter? Page 14.
Page 14.
20th April 22.
It was issued on 20th April. Communicated.
So your after that the application was disposed of. 20th May.
20th May, but I did not have that letter at that point.
Oh, I see.
So as such, it was not reflected in the order.
Kindly see the second and third paragraph of this order, page 14. Why it has been dropped? The reason is there.
Page 14.
Page 14 of the compilation handed over by my learned friend.
Yes, yes.
The second paragraph. And whereas the said Shailanath Chaudhary retired on superannuation on 30th September 2017 during the pendency of the proceeding, and therefore the instant proceeding were deemed to be proceeding under Rule 9 of the Railway Services Pension Rules 1993 to be continued and concluded by the authority which commenced it, and whereas the disciplinary authority which commenced the proceeding remitted the case to the president in terms of proviso to Rule 9(2)(a) of the aforesaid Pension Rules 1993. Now the Pension Rules comes into play. Pension Rule stands alone, whether the contractual relationship is there or not.
19(2)(a) of the pension rules means the sanction of the president.
No, the Railways Pension Rules. Kindly take my supplementary affidavit.
No, what point you want to make out from this?
Now the proceeding, since he has retired, now the proceeding becomes converted to a proceeding under railway service pension rules of 1993, where we can recover the defaulted amount from his DCRG benefits. That rule is there. We have no enmity with him. We are not doing anything at our will and wishes. We are following the law. That I have annexed in the supplementary affidavit.
So previously he is not covered under the CCS pension rules?
No, not. This rule applies. He is a railway servant.
You are a railway servant. Achha, then you left it incomplete. What did the memo last said?
Last said it has to be dropped because the employer-employee relationship is no more.
Yes.
That is the reason. So it becomes converted to a proceeding under railway service pension rules. It has to be because the rule provides.
So interpretation.
The rule is there, my lord. That is my case. The rule is there.
A fresh memo then, Mr. Mittal.
Not required. Railway service pension rule says that DCRG benefit can be withheld. The reason for withholding the DCRG benefit is that a clearance certificate has to be issued from the storage department. Now in this case, what has happened? The storage department is not issuing the clearance certificate because there is a 30 lakh stored debit. That is a defaulted amount. So unless the clearance certificate comes from the storage department, the DCRG benefits, the pension department could not issue the pensionary benefits, DCRG benefits. That is where the thing is right now stuck. Because we are going to recover it from the DCRG benefits. At least, my lord, he should furnish a security. If my lord is ultimately, my lords are ultimately inclined to dismiss this writ petition, at least, my lord, direct him to furnish a security to the defaulted amount because audited balance sheets are there.
How many did you recover? How much did you recover from?
38,000 we have recovered out of 30 lakhs 14,000.
He obtained a stay from the tribe.
Now the
What were you sleeping? Huh? So you yourself made the passage for him that run through this passage, you will be gone.
That does not mean, my lord, he is defaulted.
And illegality has been stalled by on the order of a court. Your officers will not go and file a vacating application. You are saying that you take advantage of the officers of the fault. You are telling him. He becomes emboldened, again goes to trial.
Well, at the end of the day, it is a public money. It has to be accounted for.
Thank you so much. Otherwise, we would have
He should be
disclosed
thankful.
his absence also.
His client should be thankful that during his service tenure, we have not initiated a CBI inquiry. He would have been in deep problem then.
Who told you not to initiate?
We did not.
Tell you that
We
go
did
and
not.
initiate
We did
CBI.
not. That is a relationship perhaps maintained by.
Make your argument on this.
My lord, kindly come to the supplementary affidavit. May I place, my lord, paragraph 2. The short supplementary affidavit, 3-4 pages. I say that the petitioners have preferred this instant writ petition challenging the impugned order dated 16/2/2008 passed by the learned Central Administrative Tribunal in OA number 189 of 2013, whereby the tribunal was pleased to pass an order in favor of the respondent without appreciating the fact that while holding position of senior section engineer PV and while in charge of the unit, he was or is accountable for the loss of the materials which the respondent herein has taken charge from his predecessor, who had never reported any shortage or loss of materials before his transfer to BNDM. This is wrong. Bardhaman is wrong. Unit, and such shortage was discovered upon an inventory of materials and preparation of stock sheets. In such circumstances, the entire liability is cast upon the respondent, against whom a valid and lawful recovery proceeding has been initiated according to the appropriate rules and regulations. Now, I will paragraph 4. It is pertinent to mention that stored debit assessed by the stock verified wide stock sheet number such and such dated 30/9/2010 and such dated 15/9/2010 is amounting to rupees 14,71,892 and rupees 15,62,963 respectively. Accordingly, the recovery of stored debit of rupees 30,34,855 started from the salary of the applicant, and 2 installments at the rate of 19,000 per month from January 2013 and February 2013 was done. And thereafter, the balance amount of 29,96,855 could not be recovered as the applicant has filed OA number such and such. The Honorable Tribunal, by interim order dated 26/3/2003, has stayed on recovery by railway, and in the meantime, the applicant had retired from service on 30/9/2017. The said OA was disposed by the order dated 16/2018, that is after the retirement of the applicant. Hence, there was no other option left for the railway administration to recover the stored debit amount from retired dues, that is DCRG and pension relief, and accordingly, the DCRG was withheld due to above reason as well as pendency of another disciplinary case pending for decision of sanction of precedent.
So as the authority in support of this state.
My lord, may I just continue the next paragraph? Now, the presidential sanction against the above disciplinary proceeding has been closed as intimated by the Joint Director, Vigilance Railway Board, by his letter number such and such dated 24 June 2022. However, the retired dues cannot be released at this stage due to pending of stored debit. The applicant retired holding the charge of stores, and as per procedure circulated by Southeastern Railways Establishment Serial number 170 of 1998, the DCRG dues shall not be released till such time the clearance certificate is received from concerned stores. This is what I was saying. In the instant case, an amount of rupees 30,34,855 was pending towards stored debit. As such, the DCRG could not be released as there was no clearance certificate. As the amount of recovery is large and handsome amount, as such the same is required to be recovered from his pending DCRG as well as from DNS relief.
This you have done in terms of this establishment.
Yes, that is annexed at page 6.
Read the given as per Rule 15 to.
Rule 15 I shall place, I have annexed that. If you kindly come to page 6.
Yes.
This is the establishment, the last portion. The establishment serial number 170 of 98 dated 12/8/1998.
Last 117.
Page 6.
Page 6. Oh,
Page 6, last part.
Yes.
Establishment serial number 170 of 1998 dated 12/8/1998. Kindly see the heading, the preamble. Procedure for issue of the clearance certificate at the time of retirement of railway staff holding the charge of railway stores. He was in the charge of the railway stores. So he has to obtain a clearance certificate from the concerned stores. Now I will kindly come to page 7, next page. Page 7, clause 6. May I please it? associate accounts of his pension shall not release the discharge dues till such time clearance certificate is produced by the personnel branch along with settlement papers. We are creatures of statute. We cannot override our own rules.
This circular has been issued under borrowing power from what? Is this in consonance with your rules, pension rules?
No, this is establishment serial. These are
So what is will this override the statute?
statute deal. The Railway Act does not deal with these formalities.
That issued under which provision?
Railways Act it has to be.
So your argument is due to clause 6, we have the right
Yes.
to withhold.
To withhold. Now I am coming to recovery. Recovery is Railway Service Pension Rules 1993. That is at page 8. Clause 15. May I place it, my lord? Recovery and adjustment of government or railway dues from pensionary benefits. This is the heading. Now, my lord, kindly come to clause 3. For the purpose of this rule, the expression railway or government dues includes, kindly come to clause B. Dues other than those pertaining to railway or government accommodation, namely balance of householding, this does not apply, or conveyance or any other advance, overpayment of pay and allowances, leave salary or other dues such as post office or life insurance premium, losses. Now this applies, this part applies. Losses including short collection in freight charges, shortage in stores, caused to the government or the railway as a result of negligence or fraud on the part of railway servant while he was in service. This part applies. Now, my lord, kindly come.
Rule 15, first paragraph. Read 1.
For the dues other than the dues pertaining to occupation of government or railway accommodation, the head of office shall take steps to assess the dues 1 year before the date on which a railway servant is due to retire on superannuation. This has been done. The audited audited accounts are there. In the impugned order of 19th October 2012, the audited account statements are referred to. Now, my lord, kindly come to the next page, page 9, clause 4. May I place it, my lord? A claim against the railway servant may be on account of all or any of the following. Clause A. Losses including short collection in freight charges, shortage in stores caused to the government or the railway as a result of negligence or fraud on the part of the railway servant while he was in service. This is the provision under which we can recover. Because this is ultimately the loss of the railways.
Now, what is your argument as regards conversion of proceedings? Where do we find that?
My lord, my first argument is that initiation of disciplinary proceeding is not sine qua non for recovery. It cannot be, because what is the purpose of disciplinary proceeding? Is to prosecute the delinquent employee and to come to a finding, impose penalty. We can impose fine, penalty, compensation, whatever, or dismissal from service, removal from service, major penalties, minor penalties, whatever. But what is recovery? Recovery is realization of the amount which has been defaulted. We cannot realize the amount in a disciplinary proceeding. We have to take resort to these rules. For the sake of argument, my lord, I initiate a disciplinary proceeding against him. The end result will be he will be dismissed from service. But what will be the recovery? It's a public money ultimately. Railways is not fighting this case for their own gain. They have to account for this huge amount, 30 lakhs of rupees.
So, was the procedure by which, without initiating any sort of steps, only by issuing a recovery memo?
That is this clause 6. Clearance certificate is required.
No, that is your circular clearance certificate.
And rule 15 is.
He cannot get a clearance certificate.
Yes.
To show us that after you are right, your argument is disciplinary proceeding is not the sine qua non to recovery.
Yes.
Now, this recovery after retirement, as you argued, that it now converts as a proceeding under Railways Act.
Railway Service Pension Rules.
Which provision says so?
Clause 15. Rule 15.
The proceeding. Rule 15 is what?
Rule-
Rule 15 says that a claim may be on account of such and such.
Recovery and adjustment of government or railway dues from pensionary benefits.
Yes.
So the due, what is due? Due has been defined in clause 3. I am relying on subclause B. So that due has to be recovered from his pensionary benefit. This is clause 15. Clause 1 starts with the word that for the dues other than the dues pertaining to occupation of government. My case falls in the first part for the dues. Now what is the due? The dues that is
To challenge the rule, not required. They have not. I have filed the original application at the stage when the recovery was sought for from the salary. I retired in 2007.
Finished?
And my lord, kindly, the fact is that show cause was issued. He did not reply. There has to be some protection.
Now the charge sheet which was issued on 29 June, that was pertaining to the self-same incident.
Yes.
Then Mr. Rufke.
Self-same, not self-same. Different. It was pertaining to disciplinary proceeding. Now this case is for recovery.
Also a recovery, an allegation of a fraud, of an amount.
Not on the self.
Like something.
That is not related to the stored debit.
Like 2,20,000.
That is not stored debit.
That is not
stored debit.
My lord, we have to.
Now, Mr. Gupta, one more. My brother has asked this. Kindly come to this clause 15B which you are referring to. Recovery and adjustment. Page 8 of yours. Please read the clause B.
For clause 3 starts with the
B.
B. Dues other than those pertaining to railway or government accommodation, namely balance of house building or conveyance or any other advance, overpayment of pay and allowance, leave salary, other dues such as post office or life insurance premium, losses including short collection in freight charges, shortage in stores caused to the government or the railway as a result of negligence or fraud on the part of the railway servant while he was in service.
Then who will prove this negligence or fraud, or in what?
The audited balance sheet is there. That is referred to in the impugned order. May I place it? May I place it once?
Yes.
That is, my lord, at page 30 of the writ petition. 30 and 31 of the writ petition.
Memo which was sent.
Yes. Kindly see the reference.
So, but how much? Only 38,000.
38,000. Kindly see the reference part. accounts note against stock sheet number such and such, dated 39/2010 of such and such unit for an amount of such and such.
Here just one question is arising.
My lord, we have to have some protection or security. We cannot catch hold of him if he goes with the entire money. We cannot, my lord, file a recovery proceeding in a civil suit and fight it for 20 hours.
Occasion wouldn't have occurred if you would have taken steps for vacation of the entry order. Then you could have extracted the money during his discipline, during his subsistence in service. Now you are making an argument that suppose I have retired in 2020. You did not initiate any proceeding against me, but there is an audit report which says that 20 lakhs I am responsible. Does it mean that after my employer-employee relationship ceases, you can revamp that claim against me after you have no relationship with me?
That claim,
The basis of Rule 15 of the bench.
that claim is a continuing claim. We are not revamping. It's a continuing claim.
Then why did you allow him to retire? You could have stopped his retirement.
His age of superannuation has come.
Maybe, but how you explain your conduct?
My lord,
You are
it's,
saying my rule says that be cautious. If there is an audit report, it is established, Rule 15 will apply, you have to take care of that.
there was a stay, so we cannot do anything.
Yes, what this is your argument.
My lord, at least, my lord, we cannot file a suit before the civil court and fight it out for 20 years.
Because the junction, you could have made an endeavor that or you have initiated a proceeding.
We have initiated, we have withheld his DCRG.
Not by way of a discipline, but not by way of a proceeding.
The not required because clause 15 says dues has to be adjusted from his DCRG.
Contention is there is no requirement to initiate.
Yes. Because it has to be adjusted from his DCRG dues. Kindly see clause 15, recovery and adjustment of government dues from pensionary benefits.
Yes, Mr. Singh.
Well, para 6 of tribunal sort. Para 6 of tribunal sort, which is under challenge before Lord. Para 6 of the tribunal sort, impugned order.
Para 6.
Internal page 4.
বাবা এদিকে চলো। আপনি এটা তুলে দাও। স্টেপল করে দিতে হবে, এটাকে স্টেপল করে দিন। Yes, what you are showing para? পড়ে আপনি নিজের কাছে রাখুন, না নিয়ে বসুন। Para 6. Yes, please.
What fell from lordship was also observed by the tribunal. Lord, it says on 26/3/2013, the recovery was stayed. The respondents did neither take any steps to get the interim stay vacated by preferring any miscellaneous application nor recorded their objection in the regard of contingencies. My lord, my specific case before the tribunal was that a recovery was sought to be made. A recovery was sought to be made from my salary. I approached the tribunal on the two specific orders, and my lord, tribunal granted a stay. My lord, I retired in 2017. The original application was disposed of in 2018. This is an order dated.
How does that help you?
My lord, it helps in this count, my lord.
It is admitted he did not take any step.
I approached the tribunal with a specific relief that no recovery to be made from the salary and the orders impugned to be quashed. This was my relief in the original application. Tribunal, relying on its own judgment as affirmed by the Honorable High Court, my lord, disposed of the original application, stating that you cannot recover from the salary of the applicant. My lord, I am reading the operating part.
Yes, yes. Now, where are those two orders?
Now, question arises is this thing. They have come in a writ petition. DCRG was not the issue at that material point of time because nothing happened. When I filed the original application, I was in service. DCRG was not the issue. DCRG was the immediate issue when I retired from service in the year of 2017. Now, my lord, in 2017, another charge memorandum was issued against me, which continued. I approached the tribunal repeatedly after my retirement, stating that my other settlement dues had been released, provisional pension has been released, PF, GIS has been released, RIP salary has not been released, and DCRG has not been released. The tribunal ordered repeatedly, you culminate the disciplinary proceeding because it is standing in the way of this applicant in getting the DCRG.
That was that order.
My lord, that compilation, my lord.
20th of May 2020.
Lordship. After that, the disciplinary proceeding culminated and it was dropped by a presidential order. Now, in this particular writ petition, they have nothing. My lord, I have succeeded there to the extent that nothing is to be recovered from my salary. DCRG has not come into picture at that point of time. Now, if Lordship dismisses this writ petition, it matters nothing to them, but it matters to me because of the fact I have preferred an original application which is pending before the tribunal, praying specifically of the release of my DCRG. Now, if Lordship allows this writ petition, it will be an hindrance on the tribunal to adjudicate the original application wherein I have prayed for release of my DCRG.
That is 133 of...
No, after that, after culmination of my disciplinary proceeding, everything was paid to me. Provisional.
So you should bring those things on record.
I brought, my lord.
Where?
I brought.
You have used no affidavit to this.
My lord, original.
No affidavit.
No, I have not used an affidavit, but original application
You will not use an affidavit stating that I have filed a subsequent application, and if you do not, if you interfere, I will be in predicament. You are not required to file an affidavit.
Lordship, I required to file an affidavit. Lordship gives me a chance, I shall file an affidavit.
So for this, we kept the matter pending to hear you and finish it.
The hearing was concluded, my lord. Lordship
should have taken this.
I have taken that point. At that point of time, Lordship did not ask for an affidavit. I placed this fact. Lordship had concluded the hearing upon hearing me. Because this particular original...
So you wait when the court makes a mistake.
No.
That court did not ask me
my lord, original application...
That is your conduct.
No, my lord. My lord, 705 of...
Why do you make such unnecessary submission?
My lord, I have placed that...
You are quite senior now. So you should have opened your submission that I have some facts which my lord, dear lordship, did not ask me to file any opposition. But I think for adjudication, this is necessary. You do not do so, you are smart.
No, I have
copies. জানি না আমরা ওই কিসের জন্য ফাইল করেছি সেটাই তো
স্ট্যান্ড দেখে তখন তো স্যালারি থেকে শুনতে পারবে না এখন তুমি আমার
What is your OA application file?
My lord, OA is 705 of 2023. They have filed a reply to that, contesting the original application. Only hindrance is this writ petition. My lord, they
have filed in this after the proceeding was dropped.
My lord.
Now this OA you have filed for what?
For release of my DCRG with a specific prayer. On 2 counts, they were withholding my DCRG. On the count of pendency of a disciplinary proceeding in terms of charge memorandum of 2017, which culminated in 2022, and on the count of stores debit. But stores debit part was decided in 2018 when DCRG did not surface. So now I have filed an original application before the tribunal stating everything has culminated. Kindly release my DCRG. They are contesting on the.
So that is because of Rule 15.
No, they may contest there, but in this writ petition, that is not their cause. They can withhold the DCRG because it has culminated in 2018 and it has a cause of 2012.
It is a continuing litigation, Mr. Sinha.
A continuing litigation, my lord.
Their point here is
Lordship,
tribunal was wrong in directing us to pay the entire amount.
No, tribunal has not directed that. Tribunal has said you cannot recover from salary. Lordship, kindly comes to the order. What tribunal has said? What is their grievance against this writ petition? They have no grievance. Basically, it is infructuous. My lord, I am reading, my lord. Para 8, last paragraph, page 5, internal page 5. We therefore, confronted with the contrary decisions of the tribunal on the issue whether recovery could be made from the salary of an employee without going through disciplinary proceeding. Since opinions have been expressed by the coordinated bench of same strength and affirmed by Honorable High Court, which would bind us, we are not in a position to discard the view opined by the coordinate bench in reference to the Jaipur bench decision referred super. Accordingly, we direct the respondent should refund the recovered amount within 3 months. That is the decision, finished. They have recovered 2 months of salary prior to getting of stay interim order. Tribunal directed, you cannot recover, you refund. Matter ends there. Where their grievance lies in this writ petition. They have challenged this order. Their only purpose, sole purpose is that if they succeed, they will render the original application before the tribunal praying for release of DCRG infructuous. And being the court of first instance, the tribunal has a right to hear this.
When the subsequent
But they are arguing the tribunal. They are
subsequent waivers filed 2005. 2022.
Yes. 23, my lord. 705.
This petition was filed in 2018.
18. And they are contesting this.
Your stand, if we summarize your stand, when they started recovery of the amount from your salary, you prepared original application, taking a plea that you will not be able to deduct the amount from my salary without initiating any disciplinary process.
Absolutely.
You obtain the stay on.
Lordship.
In the meantime, you return.
Lordship.
Now your stand is, I have returned. Now you will not be able to touch my.
No, I am not saying that. I am not saying that. They have a separate forum to contest. They have a forum to contest because I have.
Then we will dispose of this original writ petition.
Lordship.
Recording the fact that you have returned. The original application was for recovery of salary. Now the salary has converted it to a DCRG. And till date, DCRG has not been released, for which you have approached the tribunal.
Lordship.
We will grant them liberty to take all these points as a defense to your prayer of.
They have taken in the reply. They have already taken in the reply. That is my counter. They have already taken in the reply. If Lordship by any means allows this writ petition with order that they can recover from the DCRG, my original application before the tribunal praying for DCRG will become infructuous.
Was their defense?
Yes. But their defense is this one. And the OA have also brought. This is the reply in my lord's hand, my lord, and that is the original. This is the reply.
Which paragraph?
Which paragraph?
My lord, para 8 of the original application, para 8 of the original application.
No.
8 is the relief. Lordship has got, I prayed for release of my DCRG.
No, you are now saying that all the point raised in this.
That is the reply. That is their reply. That is their reply.
Oh.
That is the reply.
Raised in this, they have raised in the reply also.
Yes.
Please first bring it out and show it to him.
My lord, I am reading. Para 5. The applicant Sri Shoilonath Choudhury retired from railway service under superannuation on 39/2017 while working as senior section engineer PWay and instructor in the ETC CK. At the time of retirement, the Provident Fund GIS provisional pension was paid to him except commutation value, DCRG leave salary, which was kept withheld due to pending DAR case that was dropped.
Due to pending
DAR case, DAR means discipline and appeal case, which was dropped subsequently.
Oh, acha.
DAR case. The applicant filed OA number 133 of 2020, 1366 of 2021 before the Honorable Tribunal, CAT Kolkata, setting as for disciplinary proceeding. The Honorable Tribunal has passed an interim order dated 8/3/2021 in OA 133 of 2020 with the following direction. The respondents are directed to immediately release the admissible leave salary in favor of the applicant. They should continue to withhold the discharge and commuted value of pension till the final disposal of. That in obedience of the order of the tribunal, the leave salary amount was released and paid to the applicant on 16/3/2021. The Honorable Tribunal, by interim order dated 8/10/2021, had directed the respondents to take instruction about the proposed penalty and release of DCRG kept withheld since 2017. Accordingly, necessary action has been taken by the railway to obtain the orders of the President in the DAR case, my discipline appeal case, towards compliance of the order.
So where is that audit this due amount, where it is stated?
The issuing letter instruction of Personnel Department for releasing the pendency of the pending DCRG has been observed from.
No, that is DRG, Mr. Sinha. Where is this issue of
para 5E? Para 5E.
Yes, what he has said.
In terms of Rule 15(2) of the Railway Service Rules 1993, same contention, same Railway Board circular has been given, establishment circular, I'm reading. The railway government dues as a certain assessed which remain outstanding till the date of retirement of the death.
So
we will say that in the changed situation, this writ petition has become infructuous since he has retired, and we have been informed that he has filed an original application wherein you have taken a point as regards Rule 9 of the railways.
Well, that does not mean my writ petition will be infructuous, because this writ petition is a arising out of a continuing cause of action.
Mr. Gupta, you will realize from his salary now.
As per Rule 15.
As per Rule, his salary concept has gone. Now he is a
not salary, no, from the DCRG.
That avenue we are leaving it open for you. How you will be agreeing?
He is wanting to save his OA and I am wanting to save my writ petition.
No. Your writ petition is for.
Actually, the original application he has filed, restraining you to make any deduction from his salary. On the basis of that subject matter, the impugn order was passed.
Right.
Now we are going.
We are making him alive. That you come back, do your service, we will recover from your salary.
Well, that can be done in a writ petition in a WPCT.
Sorry. Yes, the present writ petition has. Give us the reply.
But I have given.
No,
Oh, sorry.
ওইটা একটু দাও।
অর্ডারটা দিয়ে দিচ্ছি।
5E বললো না। 5E you said.
5E onwards.
The present writ petition has been preferred by Union of India and its functionaries, challenging an order dated 16th of February 2018, passed by the learned tribunal in the original application number 189 of 2013. The said original application বলেছো না, ব্র্যাকেটে হিয়ারিং আফটার রেফার টু অ্যাজ ওএ করে দেবে, বিং ওএ নাম্বার 189 of 2013. Stuff. The subject matter of challenge in the said OA was a memo dated 19th October 2012, two memoranda dated 19th October 2012 and 18th December 2012, by which the petitioners hearing directed recovery of an amount of rupees 19,000 per month. By which the petitioners herein by which the petitioners herein whereby and whereunder the original applicant stroke respondent hearing was intimated about shortage of stores reflected in the stock sheets, and in connection therewith a decision for recovery of an amount of rupees 30,34,855 towards stores debit from his salary at the rate of rupees 19,000 per month with effect from November 2012. Records reveal that in the said records reveal that in the said OA, initially an interim order was passed on 26th March 2013, and the same continued till the disposal of the original application by the order impugned in the present writ petition. Stop. Subsequent thereto, in the midst thereof, the respondent retired from his services on 16th February 2018. কোথায় গেল এটা ওই যে কপিগুলো দিয়েছে 2018 retired from his service on কত বললো 30th September 2000 retired from his service on 30th September
30th September 2017.
30th September 2017.
Well, may I indicate one thing? The original application was subsisting then. He did not brought that fact before the tribunal that he has retired.
Which one?
The original application OA 189 of 2013.
What were you doing? You had no say.
Carriage of proceeding lies with the petitioner, my lord.
Oh, so you will keep silent. So why you are making?
Now he is taking our point of superannuation.
Your ultimate aim was to not to allow him scot-free to go with his DCR.
Yes.
We are protecting him.
My lord.
Arki. You also? In the midst thereof, the respondent retired on 30th September 2017. And prior thereto, a charge sheet was issued against the respondent on 29 June 2017. The respondent thereafter filed one original application being OA 133 of 2020 seeking a direction upon the petitioners to release the withheld DCRG, leave salary and commuted value of pension.
And conclusion of the DP, disciplinary proceeding. And conclusion of the disciplinary proceeding.
Stop. He filed another original application being OA 1366 of 2021. Since due to pendency challenging challenging the charge sheet. Challenging the charge sheet.
Disciplinary proceeding. Disciplinary proceeding. Disciplinary proceeding or charge sheet?
Challenging the disciplinary proceedings initiated by the charge sheet dated 29th of June 2017. Both the said original applications were taken up together and upon contested hearing, both the applications were disposed of with a direction upon the petitioners hearing to pass a final order within a period of 2 months within a period pursuant to such direction. Stop. However, at the time of such disposal, the parties did not bring it to the notice of the learned tribunal that on 20th April 2022, the competent the president noted the competent authority came to a conclusion that the proved charges do not constitute grave misconduct and accordingly decided to drop the proceedings against the respondent. Stop. Subsequent thereto, the respondent preferred a fresh original application, being waived
705.